South Africa's legal system. Law, brew. It's everywhere. It's the rules of the game, the do's and don'ts, the things that keep our society running somewhat smoothly. In South Africa, our legal system is like a delicious potjiekos, a mix of different ingredients that come together to create something unique. At the very top we have the Constitution, the big boss, the ultimate rulebook. It's like the grandma who lays down the law at a family gathering, what she says goes. Then there's legislation, laws made by our elected parliament. Think of them as the house rules that everyone has to follow. We also have common law, passed down from our colonial past like those old family recipes that just work. And let's not forget customary law, the traditions and practices of our diverse cultures, like the secret ingredient that gives our potjiekos its distinct flavor. Finally, there's case law decisions made by judges in previous cases, creating precedents for the future. It's like asking your older sibling for advice because they've been there, done that. All these ingredients mixed together create the unique flavor of South African law. Now let's talk about the two main branches of law, public and private. Think of it like this. Public law is like dealing with the government, while private law is like dealing with your neighbor. Public law is all about the relationship between the state and its citizens, the rules about how the government should behave, like paying taxes or not littering on the national highway. Private law, on the other hand, is about the relationships between individuals or groups. Things like contracts, property, and family matters. It's about your rights and obligations towards other people, like not stealing your neighbor's prize-winning pumpkin or making sure you pay back that loan from your cousin. Now let's zoom in on a specific area of private law that's super important, the law of persons. This is all about who's who in the legal world, who has rights, who has responsibilities, and who can do what. It's like figuring out who the adults are at a party and who are still waiting for their juice boxes. The law of persons is like the bouncer at a club. It decides who gets to come in and enjoy the legal privileges. It determines who can sign contracts, who can get married, and who can be held responsible for their actions. It's all about legal status, baby. In the eyes of the law, there are two main types of persons, natural and juristic. Natural persons are easy. It's us. Every human being from the moment they're born is considered a natural person. We have rights, we have responsibilities, and we can do things like own property, enter into contracts, and sue someone if they wrong us. But here's the kicker. The law also recognizes juristic persons. These aren't people you'll bump into at the grocery store. They're entities like companies, organizations, and even trusts. Think of them as groups of people or assets that are treated as a single unit under the law. They can do many of the same things that natural persons can, like owning property, entering into contracts, and yes, even suing or being sued. So yeah, the law gets pretty creative sometimes. It's not just about protecting individual humans, but also these artificial entities that play a big role in our society and economy. Section 5. Legal subjectivity, rights, duties, and you. Now let's talk about legal subjectivity. Don't worry, it's not as complicated as it sounds. Basically, it means having the ability to hold rights and obligations under the law. It's like being a player in the game, rather than just a spectator watching from the sidelines. Every natural and juristic person has legal subjectivity, but it's not always a level playing field. The extent of your rights and obligations can vary depending on factors like your age, mental capacity, and even your criminal record. Minors, for example, have limited legal capacity compared to adults. They can't vote, drink alcohol, or enter into contracts without their parents' permission. It's all about striking a balance between protecting the vulnerable and ensuring everyone has the opportunity to participate in society. Section 6. Capacity conundrums acting your age. Speaking of capacity, there are actually different types of it in the legal world. There's legal capacity, which is the basic ability to have rights and duties. Then there's capacity to act, which is the ability to perform certain legal actions, like signing a contract or getting married. And finally, there's capacity to litigate, which is the ability to sue or be sued in court. Now here's where it gets interesting. Your capacity to act and litigate can be limited, even if you have full legal capacity. Minors, as we mentioned, have limited capacity to act until they reach a certain age. People with mental disabilities may also have their capacity to act limited if a court determines they're unable to understand the consequences of their actions. It's all about making sure that people are only held responsible for actions they're capable of understanding and consenting to. Section 7. The Constitution's Impact Equality for All. Now, let's talk about the big kahuna of South African law, the Constitution. It's like the referee in the game, making sure everyone plays fair and no one gets away with foul play. The Constitution guarantees fundamental rights to all individuals regardless of race, gender, religion, or any other grounds. It's all about equality, baby. This means that any laws or practices that discriminate against certain groups of people are unconstitutional and can be challenged in court. So, even though the law of persons might differentiate between people based on factors like age or mental capacity, it can't do so in a way that violates the Constitution's commitment to equality. It's a beautiful thing, really. The Constitution is there to protect the rights of all South Africans, ensuring that everyone has an equal opportunity to thrive and prosper. Section 8. Customary law tradition meets modernity. Now let's talk about customary law, the traditions and practices that have been passed down through generations in our diverse cultures. It's an important part of South African law, recognized by the Constitution itself. But here's the catch. Customary law must always be in line with the Constitution. This means that any customary practices that violate fundamental rights, like equality or dignity, are not legally binding. It's a delicate balancing act, respecting our cultural heritage while also upholding the rights of all individuals. It's all about finding a way for tradition and modernity to coexist peacefully, respecting our differences while also recognizing our shared humanity. Section 9. Upholding rights, the importance of legal understanding. So, there you have it, a crash course in the law of persons in South Africa. It's a complex area of law, but it's also incredibly important. Understanding your rights and obligations as a legal subject is crucial for navigating the legal system and protecting yourself from exploitation or abuse. Whether you're signing a contract, getting married, or starting a business, knowing your legal status and capacity can make all the difference. So stay informed, stay curious, and remember, the law is there to protect you, but you need to know how to use it. That's all from me, folks. Stay woke, stay safe, and remember, knowledge is power.